Hi, my name is Zalman Ainsworth. Thank you for tuning in for another episode of Retail Stories. Today I'm really excited to have Ken Gray from ABL. Ken has 35 years of experience in property law here in Melbourne, Australia. Ken has a very big and successful reputation in representing some of the biggest landlords and tenants. Ken has enormous amount of knowledge and experiences that we could learn from to apply to what we're all doing. Ken, thank you very much for agreeing to sit down for an interview on our Retail Stories series. I've known you for my entire time of working in commercial real estate. You're one of Melbourne's most high-profile property lawyers and well-respected and trusted by many. And it's a real privilege to sit across next to you now and conduct this interview, so thank you.
Thanks, Owen.
You've been in property law for 35 years, 30 of which at ABL.
Correct.
So you've seen a thing or two about most experiences. In your 35 years experience in property law, was that enough experience to prepare you for 2020?
Well, I don't think anything prepared any of us for 2020. I certainly didn't expect at any stage of my career to be operating a legal practice from a spare bedroom. It's just nothing really prepares you for that. It was never contemplated at any time in the previous 35 years. We always assumed we could operate, reasonably normally, even if the market was dead or transactions were a problem, or things like the GFC hit or the crash of the 80s. All of those things were pretty mild compared to being locked up at home and not able to interact with clients or your own staff or other lawyers, and it was certainly a unique experience.
So what would be your biggest takeout from that entire experience from your spare bedroom at home?
The biggest takeout was just how hard it is to maintain contact with multiple people in an office environment when you're trying to do it remotely. Instead of walking through an office, having casual conversations with people, having to text them, phone them, email them, and then wait for them to respond depending on whether they're busy or doing other things. Whereas in the office environment, of course, you can walk past glass-fronted offices and see who's busy or if they're on the phone, and it's much easier to just have those casual interactions that just make the day run more smoothly.
Do you personally believe in this new change to working from home?
Look, it depends. I think there are certainly different segments of the workforce that can work from home relatively indefinitely. In our practice, younger lawyers who are learning from observing and working alongside older, more experienced lawyers, I think it's very, very difficult to do that working from home. Certainly not predominantly. But I think I think that the whole experience of working from home and COVID, it will be that there'll be a more flexible attitude where it's appropriate for people to work from home.
Sure. So you personally, and obviously ABL, represent both a lot of major tenants and major landlords. If you can give one single message to both landlords and tenants going into this year, what would that one message be?
I think the message of COVID, like any crisis, is that crises tend to present opportunity, and it's easy to focus on the downside and the risk and perhaps the fallout. But what we've seen with a number of the smarter operators, both on the landlord and the tenant side, is that they've used this crisis to position themselves for hopefully what will be much better times beyond COVID.
And in your own opinion, what's the biggest structural change to the property and more specifically the retail landscape as a result of last year?
I think the most dramatic change has been just that divide between the winners and losers. There were a lot of winners out of COVID, obviously supermarkets, large electrical stores, the list goes on, of those who actually benefited from people being cooped up at home. And there are a lot of significant losers. Obviously the hospitality industry, travel, tourism, and food and beverage industry as well took a big hammering. So that I think was the biggest sort of change we noticed, that those who, many of those, particularly in travel, hospitality, tourism, perhaps their business model may not be there when we get back to some sort of normalised activity again. But it certainly, there was a sharp division where there were those who did well and those who did not so, who did very badly out of it. And it was quite stark.
And how's that translating into 2021 and beyond?
Well, in terms of what lies beyond, I guess those who have those who have done well are looking to capitalise on that, and those who have been affected badly, particularly in the travel, hospitality areas, are, I guess, trying to work through what is actually sustainable, what works, in a post-COVID world where they particularly have to manage those risks, as opposed to those who, for example, like supermarkets, saw that really COVID was perhaps the worst thing that was thrown at the retailing industry, and yet they were reasonably immune. One of the few parts of the industry that were not shut down, and they were reasonably immune, and they operated pretty successfully through that whole process. Obviously, put strains on logistical chains and those sorts of things, but generally speaking, they did well. So I think the issue is really a sector by sector one, that depending on which sector people were in, how badly they were affected or how well they benefited from it, will dictate sort of how they think about things going forward.
In all your years looking at retail leases and seeing the industry from inside out, if you could make one single change, what would that single change be?
Well, as a lawyer, I would like to change one aspect of retail legislation, which is really standardising it. For those of us who work across borders, it makes no sense that Victoria, New South Wales, Queensland, all of the states have different retail different legislation that regulates retail leases. What is a retail lease in one state isn't necessarily a retail regulated lease in another state. And having those changes makes life very difficult when companies are trying to operate across borders and they're regulated in some states but not in others. And there's just no good reason for it. I mean, going back to when I started practice, each state had its own companies legislation, and we now have a Uniform Corporations Act across Australia, and that's how it should be. And I think retail leasing is one of those examples that there's no good reason to have state variations.
It's very confusing, particularly that a lot of businesses cross states regularly.
Yeah, absolutely. And in some states it's surprising which entities are actually, some very substantial entities are protected, whereas others are not. And it's random, it's fickle, and it should just be a standard definition that's applied across the country, and the regulation that sits behind it should be standardised so that businesses have some certainty if they move from one state to another, that the same rules apply.
And it became very confusing and frustrating when the Code of Conduct had different rules in every state. And for retailers across all states, they were just in 5 different places trying to work out what this all means. On the Code of Conduct, in your opinion, did it do what it was designed to do? And if you were asked to make a change or draft it or design it, what would you have done differently?
Look, I think it's easy to be critical going back. The Code of Conduct was created, pretty quickly by the federal government in cooperation with the state governments. Each state then created their own legislation and regulations to go with it. We've got a federal system, and the states have powers and controls over different areas of law within that system. So it is complicated. It had to be done in a very quick time frame to give business some certainty. So generally speaking, it had the desired effect. It gave business that sort of breathing space in terms of rent relief and the moratorium on termination of leases, which a lot of businesses were needing when they were shut down. The one thing which I think didn't work so well is that the Code of Conduct was set up, and the legislation and regulation that followed it assumed that SMEs, or small and medium enterprises as they were defined, were only on the tenant side. And you and I both know plenty of SMEs that are landlords, small businesses, family-owned, or very often individuals owning commercial property who then lease their premises to, in many cases, much larger entities. And there was a bit of a power imbalance where tenants who had the benefit of the code were, in a sense, exploiting that power given to them under the code and the regulations against landlords who were quite a bit weaker than them financially. So I think a more even-handed approach in the code would have been better to have had more, given more power, or a little more balance tilted towards landlords who themselves were small and medium enterprise.
Yeah, and I got a lot of landlords who said, it's all helping the tenant, but we're also struggling. Without rent, we can't afford to hold our properties.
Yeah, and that fed itself through even things like the structure of the regulations allowed tenants where their trading position got worse during the relief period, they could apply for more relief. What it didn't do was allow it to be wound back the other way, where, as occurred in a number of sectors, as things opened up, the tenants' turnover actually improved significantly month on month. But there was nothing in the regulations to allow a landlord to put their hand up and say, hey, listen, can we go back and revisit that relief because you guys are now doing much better than you were. So it was tilted, perhaps deliberately, but it was tilted very much in the tenant's favour, and there wasn't, in hindsight, perhaps there should have been a little more protection given on the landlord side.
There's a lot of these code of conduct negotiations still carrying on from last year that just have not been finalized. What would your advice be to a landlord and tenant that are still dragging out these conversations and negotiations now into February 2021?
It falls into two categories, I guess. One is there tend to be those leases where the leases have either ended or are close to ending, and the tenant's not intending to continue the relationship, in which case, perhaps they have an incentive to continue the debate. We've found the Small Business Commission to be reasonably effective in terms of engaging in resolving those disputes. So I think to the extent that parties are bogged down and they're not getting any traction, the Small Business Commission has been reasonably effective in trying to resolve and bring those things to a head, and also just having an external party who the tenant and landlord are answerable to. If they are behaving unreasonably or not progressing the matter, they're not unresponsive, then having that third party there is useful. Beyond that, obviously, for those who are on longer term leases, at some point the parties have got to stop arguing about the past and think about the future. So there's probably a slightly different conversation to have there about focusing on what the future arrangements are going to be, and that does give the parties particularly landlords, a bit more scope to either blend or allow a transition, if you like, of the problems of 2020 to be worked through in terms of the future.
It's a really strange scenario that no one has seemed to have experience in dealing with, and we're all just making it up as we go. And again, if there's something in the future to preserve that relationship, I feel those conversations are a lot more productive than when the lease is expiring anyways, and it's more of a how little can I pay or how much can I get.
That's right.
A very big topic of conversation in the retail industry is turnover rents versus base rents. So there's a bit of a debate playing out as we speak. Tenants want to pay turnover only, landlords want both base and turnover. Now, I know, just to qualify this question, you represent both the landlords and tenants, and you got to be quite neutral in your personal opinion. But if we can take a step backwards, what do you think, how the best way to play this debate out, that everyone gets to win and protect their income?
Yeah, and that's right. And I think the issue is really one around what does the overall financial model look like? Because if you're just focusing on one thing, which is base versus turnover, sitting behind that then is usually a bunch of other financial terms, such as landlord contributions. And I think what's going to happen is that if tenants are pushing harder for turnover-based rents, then what they'll find is that landlords will be less inclined to make landlord contributions to fit out or other works. Incentives, etc., are going to be modelled differently, because with a fixed rent, a landlord could financially model out what the return was over the term of the lease, and therefore what they could afford to provide to a tenant up front. If it's a turnover model, I'm not a financial modelling expert, but I'm assuming landlords would feel much more inclined to say to a tenant, well, if you are insisting on a turnover base and we've got no data or no underpinning of what that turnover is, then you fund your setup, because you take the punt on how well you trade or not, because we're not, there's nothing to underpin our, a financial contribution we could make. So I think everyone's got to realise that for every time you move the lever in a financial structure, such as leasing, it's going to affect something else. So a tenant's got to then decide, well, what's more important? Is it more important that I get that incentive, I get that fit out up front contribution, or is it more important that I go to a pure turnover model, or is it a blend of the two where there's a base and a turnover component?
If you owned a shopping centre, how would you manage it?
In that context?
Assuming that you don't own a shopping centre, and maybe you do.
Well, if hypothetically I did, look, I think there would be, when you look at markets broadly which have had a lot of turnover rent models in them, so airport retailing is a good example, which traditionally was heavily turnover based. Those over time have gradually crept to a base plus turnover, just because it allows parties to have some certainty that, perhaps the issue has been that the bases have crept up too much, and there's been the componentry, if you like, between the base and the turnover has been skewed one way, and perhaps what will happen is it will now move back, the dial will move back to perhaps a slightly lower base, but with a cut in for turnover rent earlier, so that therefore the tenants are not stuck on high bases if there is a drop in turnover. But I think most, if I adopt the sort of principles that most of our successful shopping centre clients have had, if I were to decide to go into that market, I think those who've been most successful do tend to treat the tenants as partnerships, as a collaboration, long term. One of the earliest ABL landlord clients I had said to me, I don't buy property, I buy tenants. So that concept that the tenant is all important in a relationship is I think is a successful way of trying to preserve, the long-term value in property.
I know this is a bit difficult to answer these questions considering you represent both landlords and tenants, and you have to have both their best interests. But back to that debate of turnovers, online trading is becoming a very big part of that. So is a landlord entitled to capitalize on online trading, and is a tenant entitled to keep that to themselves? And where is that? Yeah. Where is the middle ground that both parties again can be win-win?
Yeah, look, I think the middle ground is that if a tenant's conducting effectively a bricks and mortar operation, but they also conduct online, those two things can operate independently. If the tenant's running a warehousing business and it's all automated and all just gets sent off from a remote location, and you're running a storefront in one of the strip centres or in a shopping centre, there's really not that much connectivity other than perhaps some branding and client awareness or customer awareness. But as we've seen with a number of the larger retailers, if they're then using your storefront for click and collect or other means to connect their customers, physically connect their customers to that online activity, then I think it's reasonable for a landlord to say, well, if you are using my real estate in a way, even if it's indirect, in order to consummate a sale, then I should be entitled to some remuneration for that, because you wouldn't be able to complete that sale had you not used my real estate. So I think that's the middle ground. If there's no real physical connectivity between the storefront and the online business operations, then I think it's less open to a landlord to say I should be getting some share of that activity.
Ken, what would your advice be to anyone watching this on the best TV series to really invest their time into right now?
I really liked The Queen's Gambit. I thought that was really well done. Going back a little into 2020, the fourth season. Fourth season, The Crown was great. Just production values, and Gillian Anderson as Maggie Thatcher was pretty compelling watching. But there was, I think all of us got much more familiar with our TVs over 2020. There was a lot of not so good, but they were a couple of the better ones.
The standouts that you'd recommend? Should anyone find the time working from home to watch a bit of TV?
Well, exactly.
Ken, thank you very, very much for taking out the time to talk to us about what you've experienced last year and what advice you'd have for both landlords and tenants going into this year. I've only had great experiences with you, and I've really enjoyed our relationship over the years. You've certainly taught me a lot and helped a lot of people that you and I both call customers. So thank you, and good luck for this year.
Thank you, Zolman, and to you.